Stop and identify statute. We know if police have a reasonable suspicion, police may make a stop. But the issue now we are going to discuss is this. After police make a stop, the police may actually ask the suspect to identify himself. So the issue is whether the person is obligated to identify himself, or the person could refuse to identify himself. The issue, most specific issue here is, according to the law of some states, to refuse to identify oneself itself could be an offense. So that is, we need to discuss. What we need to discuss is whether this kind of stop and identify statute is constitutional or not. We need to look at two cases to understand this issue. The first one is Brown versus Texas. In this case, the police stopped the defendant without a reasonable suspicion. And after the police made the stop, the police asked the person, the suspect, to identify himself. Of course, the person is a defendant. The defendant refused to identify himself, and the defendant said, I did not do anything wrong, and why do you want me to identify myself? But according to a statute of the state of Texas, a person would be committing a criminal offense by refusing to identify himself once if he was asked by the police. So the issue is whether this statute was constitutional or not. So once again, the issue is the issue we have in the case was, according to this Texas law, there could be, it was a criminal offense for refusing to identify oneself if the person was asked to identify himself by the police. So the ruling in this case was, the court in this case actually ruled this Texas law was unconstitutional. But we need to pay attention to this issue. This ruling was not because the statute says it was a criminal offense for a person to refuse to identify himself when asked by the police. That was not the issue. The issue, or maybe the reason for the ruling of the court is this. The court said in this case, police did not have a reasonable suspicion to stop the person. So the court said, if a police did not have a reasonable suspicion to make the stop to begin with, and then later on the police could not really say the person committed an offense simply because the person refused to identify himself. So it is important we pay attention to this issue. The court made this ruling mainly because the police made this stop without reasonable suspicion. If the police made a stop without reasonable suspicion, and then the police later on cannot really charge the person with the offense of refusing to identify himself. So this point is important, and also this point is made clearer in the next case. In the next case, that is Hebo versus 6th Judicial District Court of Nevada. So here the issue we have was the constitutionality of this Nevada statute, Nevada Stop and Identify statute. In this case, the police actually had reasonable suspicion to stop the defendant because this was a domestic violence situation. So the police responded to the call, and then the police, and then because there was a domestic violence involved, and then the police actually had a reasonable suspicion to investigate investigate the incident to stop the person. So the police arrived at the scene, and then the police asked the person, the defendant, to identify himself. And the defendant refused to do it, and then according to this Nevada statute, it was also a criminal offense to refuse to identify oneself. But in this case, the court said this Nevada statute actually was constitutional. The reason why the court made this ruling was because the police actually had a reasonable suspicion to stop the person. So the court said the difference between this case and this previous case, this Brown versus Texas, was in this Nevada case, the police actually had a reasonable suspicion to make the stop. And then there's another point we need to mention, that is according to this Nevada Supreme Court's decision, when the police ask the person to identify himself and then how the person should identify himself, the Nevada Supreme Court said the person only needed to provide his name. So the requirement is very clear. So the court said if a police had a reasonable suspicion to make the stop, and also if the person was told the way he should identify himself was simply to tell his name, and then if the person refused to give to identify himself, and then his conduct could be a criminal offense. So that is really what the court ruled in the case. Meaning is this Nevada stop and identify statute was constitutional. There is an issue we also need to point out. That is the requirement to identify oneself cannot be vague. We know in this Nevada law, the way to identify oneself was to tell the name. So that was a very clear requirement. But the court in the case actually mentioned a case in California. In that California case, and then the California law required that a person being stopped to provide credible and reliable identification. And then in that case, the court said this California law was unconstitutional because the requirement was vague, was unconstitutionally vague. Because we need to understand the issue. The law says upon being asked by the police, the person should provide credible and reliable identification. And then we would have a question, what is credible and reliable identification? Say if the person would provide driver's license, the person would provide a student's ID, maybe the police would still say this identification is not credible, this identification is not reliable. So that creates a situation. Whether this satisfactory identification is provided, that is entirely up to the police officer's discretion. So the court said we could not have this kind of a vague requirement. So that was the reason why in this California case, the court actually struck down this law. But of course, in contrast to this California case, in this Nevada case, we know the way to identify oneself was only to tell the person's name. So the court said in this Nevada case, the Nevada law actually satisfied this constitutional requirement. That is, first, the police actually had a reasonable suspicion to make the stop. And secondly, the way to identify oneself was also very clear, was simply to tell the name. So based on those 2 points, the court said this Nevada stop and identify statute was constitutional.